August 2016 is illegal, unlawful, invalid, irregular, ultra-virus, and unconstitutional. B, a declaration. Put off your video. Paul, somebody, Paul, put off your video and put off your mic. Yes, Ogundayomi Olasunkanmi Paul, put off your video and put off your mic. You see, somebody is there naked without clothing, and your video is on. I don't know, in his office, one FT man looking like a bouncer without clothes, and they don't know that the world is watching the proceedings. Anyway, B, a declaration that the procedure leading to the termination of the employment of God. Sorry. B, a declaration that the procedure leading to the termination of the employment of the claimant with the defendant via defendant's letter of 31st August 2016 was done without fair hearing and as such unconstitutional. B, an order revoking or setting aside the termination of the employment of the claimant with the defendant. D, an order reinstating the claimant into the employment of the defendant and up-to-date payment of all accrued entitlements to the claimant, or in the alternative, an order for payment of sum of 500 million naira as compensation for damages for the unlawful termination of the employment of the claimant with the defendant. The defendant filed a conditional memorandum of appearance on 26 July 2019 and a statement of defense via a motion on notice filed on 4th October 2019. The claimant filed a reply on 10th February 2020, and by a motion filed on 23rd March 2020, the claimant filed additional witness statement of Oluwatobilola Adeoye Olowo. The facts of the case are that the claimant was an employee of the defendant and was employed on 23rd October 1990. The defendant made an allegation of illegal operation of institution of higher learning against him. After facing a special investigative panel and central disciplinary panel, his employment was terminated for services not required. This Ogun Dayomi, I said, off your mic and off your video. You will still see me and hear me. Abba. If I see this man again, I will block him. Simple instruction, he obeyed before, but maybe he feels, I don't know. Case of the claimant. The claimant testified on 24th November 2020. He adopted his witness depositions of 26 June 2019 and 10th February 2020. It is his case that he was an employee of the defendant and was employed on 23rd October 1990. His employment was confirmed by the defendant. He rose to the position of a principal manager of the defendant. Defendant made a spurious allegation of illegal operation of institution of higher learning against him. The spurious allegation was supposedly via letter written against him by some faceless students, which letter was not availed him for defense or comment. The defender hurriedly prepared a letter of termination and served same on him, relieving him of his post with the defendant. He was not fairly heard before the illegal or unlawful termination of his employment. The said petition was sent to the EFCC and he was charged and discharged at the Federal High Court on 21st November 2018. The solicitors wrote to the defendant for his reinstatement since he was discharged but the defendant replied and hinged his termination on grounds of misconduct, bordering on financial embarrassment and engaging in business against the bank's interest. He did not receive any query from the defendant over any allegation of misconduct bordering on financial embarrassment. He has not breached any of the code of conduct of the defendant to warrant the termination of his employment, testifying in his reply, which is full of repetition of the statement of facts and also repetitions within the reply. The claimant said there was no time any student asked or prayed for any refund. The purported letter of 20th January 2016 was not written by signatories to the said letter. Kayode Bankole, for instance, died in December 2015, while the other names are fake. The purported letter of 20th January 2016 is a forged document. None of the purported signatories signed the letter. Tidek Polytechnic was duly registered. He was not allowed to see or cross-examine any of the defendant's purported witnesses. He did not at any time operate any illegal institution, contrary to the query or letter of 9th May 2016 issued by the defendant. Tidek Polytechnic was duly affiliated. Tidek Polytechnic is a legal personality. Claimant tendered 8 documents in evidence which were admitted and marked as Exhibit BOJ1 to BOJ8, and the defendant tendered 6 documents in evidence through him under cross-examination, which were admitted and marked as Exhibit BOJ9 to BOJ14. Under cross-examination, Claimant said that he was invited to a special investigation panel of the defendant on 22nd February 2016. He appeared before the panel on 24th February 2016. He also received a query dated 9th May 2016 and he responded to the query. He attended the hearing of the Central Disciplinary Committee, after which he was issued a termination letter. His detour to Tidek Polytechnic is not part of his official duty with the defendant. He was the sole signatory to the Tidek Polytechnic account. He cannot tell if the staff of the Polytechnic knew he worked for the defendant. The decision at the Federal High Court was after the termination of his employment. CW2 was one Oluwatobilola Adeoye Olowo. He adopted his witness deposition of 23rd March 2020 on 11 March 2021. It is his evidence that he is a former student of Tidek Polytechnic and that he did not write any letter of 20th January 2016. He denied that any such letter was ever written or signed by the purported signatories. Claimant did not at any time dupe him or anybody at all. The claimant did not collect any illegal money from him or any student of Tidek Polytechnic. Under cross-examination, DW2 said he is not aware of any petition from the students of Tidek Polytechnic to the defendant. Case of the defendants. The defendant's witness, Mr. Tolulope Showole, adopted his deposition of 4th October 2019 on 14th July 2021. It is his case for the defendant that the defendant did not subject the claimant to the Central Disciplinary Committee on the allegation of illegally operating an institution of higher learning, but for misconduct bordering on engaging in a business that conflicted with the defendant's interest and financial embarrassment, relying on the query issued to the claimant on 9th May 2016. The defendant received a petition. Shola, you know that my ears will pick every sound, please. The defendant received a petition from representatives of Tidek Polytechnic dated 20 January 2016, bordering on unapproved status of the institution and a refund of students' school fees. The claimant was availed a copy of the petition during the hearing of the Central Disciplinary Committee. The claimant was accorded fair hearing in accordance with the defendant's Human Resources Policies and Procedure Manual HR p.m. That the prosecution of the claimant by the EFCC had nothing to do with the defendant, as the defendant was not the complainant and was not called as a witness. The claimant misconducted himself prior to his termination, which borders on financial embarrassment and engaging in business that conflicts with the defendant's interest. These form the basis of the queries issued to the claimant. Under cross-examination, DW testified that the petition by the students culminated in the claimant's termination. Some of the students were physically present with the claimant during the sitting of the panel of investigation. Only one student showed up at the hearing of the Central Disciplinary Committee, and the claimant was given the opportunity to cross-examine the student. At the first panel, the claimant did not cross-examine the students. Exhibit BOJ are not the same with the reason for his termination. The reason stated in the claimant's termination letter is misconduct. The employment of the claimant at statutory level. Sorry, gentlemen. Lola, where is the exhibit book? If people, we come for sitting, you didn't bring my exhibit book. There is something I have to correct here. This exhibit BOJ is not just BOJ, it's BOJ something. That is the judgment of the Federal High Court. Sorry, let me check my record. Claimant counsel. Claimant counsel. Claimant's counsel.
My lord, sir. My lord, sir.
The judgment of the Federal High Court was exhibit what?
My lord. Most humbly, my lord, the judgment of the Federal Court, FCB BOJ4, my lord, sir.
Exhibit BOJ4.
BOJ4, my lord.
Do you confirm, Oyetan?
Yes, my lord.
Okay. So what we have here is exhibit BOJ4 are not the same with the reason for this for his termination.
As
that
accomplished.
Is the charges, the reasons, what he was charged for in exhibit BOJ4. Under cross-examination, they are not the same reason with the reason for the termination. When we come for judgment, you bring everything about the file, not for you to choose which ones you are to bring to me. So the reason stated in claimant's termination letter is misconduct. The employment of the claimant has statutory level. That ends the evidence of the defendants under cross-examination. Final written address of the defendant. The defendant's counsel filed a 34-page final written address on 29th October 2021. The written address is of 12 font size and no spacing. Counsel addressed the issue of the admissibility of Exhibit TS2 tendered and TS3 tendered and urged the court to admit the documents. Learned counsel formulated 6 issues for determination. Counsel also raised an objection that the suit is statute barred in his issue 1. On issue 2, whether the claimant's employment was wrongfully terminated, counsel submitted that claimant's employment was rightly terminated because the claimant violated the provisions of section 6.4.2.22 IX and SI of the Defendants Human Resource and Procedure Manual HRPPM Exhibit OBOJ9, that the two offenses that were considered as misconduct committed by the claimant are 1, financial embarrassment, and 2, engaging in business that conflicts with the bank's. On issue 3, whether the defendant followed due process before terminating the employment of the claimant, counsel submitted that due process was followed in the termination of claimant's employment by following all the requirements of section 6 of the Defendants Human Resource and Procedure Manual HRPPM Exhibit OBOJ9. On issue 4, whether the claimant was given fair hearing, counsel submitted that the claimant was given fair hearing because he was queried and he replied. He testified before the Special Investigation Panel and Central Disciplinary Committee and was made to confront two witnesses who had testified against him, namely Mr. Aino and Mr. Suleiman. This was confirmed by the claimant during trial. On issue 5, whether the defendant was right when he refused to reinstate the claimant, counsel submitted that the claimant is not entitled to reinstatement because the offense for which he was discharged at the Federal High Court in suit number FHC/AD/20/C2006 has nothing to do with the reason for his, has nothing to do with the defendant. On issue 6, whether the claimant is entitled to 5 or 50 million naira as compensation for alleged unlawful termination of his employment, counsel submitted that the claimant did not specify the type of damages he claimed, whether special or general, that the claimant is not entitled to any type of damages because his case ought not to succeed, and where an employee is rightly or justifiably dismissed by his employer, no damages would be awarded. That where an employer terminates the employee's employment without notice, the employee is entitled to 1 month's salary in lieu of notice, including all his benefits accruable during the period. Number 1, the claimant was not dismissed, he was terminated. And this insistence on 1 month salary in lieu of notice. Anyway, let's go. Final written address of the claimant. The claimant's counsel addressed the court on the admissibility of documents marked tendered and other documents as issues 1 and 2, and then formulated 3 other issues for determination. Where is that sound coming from? Is it from the bar or outside the bar? I'm hearing voices. My ears are still good, and it's still very early in the morning. I'm hearing sound, sounding like a male voice. Please desist. On issue 4, whether the termination of claimant's employment was not unlawful, counsel submitted that the termination of claimant's employment was unlawful because claimant was not given fair hearing, he was not heard, and was not given opportunity to defend himself or confront the students who allegedly wrote the petition. That the claimant did not commit any offense as alleged, the defendant failed to inform the claimant of the reason for the termination of his employment in the termination letter dated 31st August 2016. On issue 5, whether the claimant has proved his case and entitled to judgment, Senate counsel submitted that the claimant has proven his case and is entitled to judgment, and he so urged the court. Defendant's reply. The defendant counsel submitted in response to the prayer for a declaration that the termination of the employment of the claimant with defendant via defendant's letter of 31st August 2016 as illegal, unlawful, invalid, irregular, ultra-virus, and unconstitutional, that the employee's remedy is in damages where the termination is held to be wrongful, that Exhibit BOJ 7, BOA, BOJ, BOJ 9, and BOJ 14 were tendered through the claimant witness without objection. The reply is basically an argument of the final written address and not a response on points of law, and not a response to points of law raised in claimant counsel final written address. Court's decision. Having read the pleadings, the evidence, the exhibits, and the final written addresses of both counsel, the court is of the opinion that the loan issue for determination is whether the claimant was given fair hearing before the termination of his appointment. Before determining the issue, there are preliminary issues to be determined, and we shall turn to them right away. This loan issue shall have children. It has one mother issue, but the mother has children at her back. Yes. Instead of putting the children as issues themselves, no, let them come under their mother. But let's treat the preliminary issue. Preliminary objection. On issue 1, whether this suit is statute by Claimant counsel submitted that the defendant is a public officer and this action was not filed within 3 months of the approval of the cause of action, that the claimant's employment was terminated on 31st August 2016. The judgment of the Federal High Court was delivered on 21st November 2018. Letter refusing to reinstate the claimant was dated 7th January 2019, while this case was filed on 26 June 2019, that the cause of action arose on 31st August 2016, when the claimant's employment was terminated, that reckoning the cause of action either from the date of termination, the date of the judgment of the Federal High Court, or the date of refusal to reinstate the claimant, the suit filed on 26 June 2019 was filed outside 3 months, so it is statute barred. The claimant's counsel submitted that this court has jurisdiction by reason of section 2541 of the 1999 Constitution as amended and the provisions of the NICN Act. That the suit is not statute barred. Counsel traced the events that took place up to the institution of this suit and submitted without conceding that the CBN is a public officer. Without conceding that the CBN is a public officer, and submitted without conceding that the CBN is a public officer, that the suit is not statute barred. That is, according to the claimant, the CBN is not a public officer for the purpose of, whether maybe for all purposes, because there are other arguments that he made submissions that shows that his position is the CBN is not a public officer for all purposes. Counsel relied on CBN versus Njamanze 2015 for Nigerian Law Report Part 1449 at 276, page 276 at 285, where the court held that CBN is not a public officer for the purpose of Section 84 of the Sheriff and Civil Processes Act, because the said section does not include artificial persons. CBN was Interstellar Communications Limited, 2018, 7 Nigeria Law Report, Part 1618, page 294, where the court held that the relationship between the CBN and the federal government is that of a banker and customer, and so CBN is not a public officer for the purpose of Section 84 of the Sheriff and Civil Processes Act. That assuming but not conceding that the CBN is a public officer, What existed between the claimant and the defendant is a contract of service, so the Public Officers Protection Act is not applicable. We relied on the case of NRMA and FC versus Johnson, 2019 to Nigeria Legal Report, part 1656, page 247 at pages 269 to 26. 266 to 267. It is to be noted that the Central Bank of Nigeria is a public officer for the purpose of the Public Officers Protection Act, being a government institution established by an act of the National Assembly. The case of CBN versus Njamanze and CBN versus Interstellar Communications are not applicable herein because in those cases, the court held that the central bank is not a public officer for the purpose of Section 84 of the Sheriff and Civil Procedure Act, because the relationship between it and the federal government with respect to federal government money, the central bank, is that of a banker customer. And so consent of Attorney General is not required to attach such monies. So you cannot take that authority and apply it across board. You cannot. In any case, what even a question that bothered my mind, which I didn't put it here, is if you as the claimant, you argue that CBN is not a public officer, then on what law are you asking for reinstatement? I don't know. You are the one arguing during your case that the employment of the claimant enjoys statutory flavor. He even extracted it from the defendant witness under cross-examination, only for you to turn around and say CBN is not a public officer. I always say you must not argue just any point just to score a point, because law is interrelated. If we agree that CBN is not a public officer, he cannot get reinstatement. It will be very difficult. It will be as difficult as passing through a camel passing through the eye of a needle for you to get reinstatement if your employment is not covered by by statutory provision. Well, in any case, it is the finding of this court that for the purpose of the Public Officers Protection Act, the CBN is a public officer. The law on this point is settled that the Public Officers Protection Act is not applicable in employment matters, claims for work and labor done, and a host of other exceptions. The case of NRMA and FC versus Johnson is a locus classicus on this point. That's the case relied upon by the Claimant Council. That is the locus classicus. The almighty pauper, that is Public Officers Act, has never applied without exceptions. There are exceptions. The law does not apply in the following cases: a claim for recovery of land; B, a claim based on breach of a contract of employment; C, a claim for work and labor done; D, where the public officer acted outside the color and tenor of his duties; E, where the wrong complained of is a continuing wrong; F, where an employer's duty to the employee is in issue. These exceptions are not exhaustive. See Captain Ogide and others versus Shona Johnson Nigeria Limited, 2009-16 NLLR Part 43, page 73. Fanny versus AGF, 2009-14 NLLR Part 39, page 387 at 398. Ibrahim versus JAC. Okay, I think there is problem of numbering here. 2, 3. Ibrahim versus JSC, 1998, 14 Nigeria Law Report, Part 5841. 4. Nwankwere and Adewumi, 1967, NMLR 45 at 49. 5. Atiyaye versus Permanent Secretary, Ministry of Local Government, Borno State, 1990, 1 Nigeria Law Report, Part 129, page 728. 6. Akwa Ibom State Civil Service Commission and others versus Aniekon Wilson Akwan, 2013, LPLR 22105CA. The second exception above. The second exception is a claim based on breach of contract of employment. The second exception above has been recently laid to rest by the Supreme Court in the case of NRMAFC versus Johnson 2019 2 Nigeria Law Report Part 1656, page 247 at 270, where Ariwola JSC held as follows. There is no doubt a careful reading of the respondent's claim will show clearly that it is on contract of service. It is now settled law that Section 2 of Public Officers Protection Law does not apply to cases of contract. In a consenting judgment, Akas JSC also held, since the action instituted by the respondents is a contract of employment, the Public Officers Protection Law cannot be involved to bar the action undertaken by the plaintiff's respondents. Accordingly, this case is not statute barred, as the Public Officers Protection Act is not applicable to the case. This objection fails and is dismissed. Merit of the case. In determining the merit of the case, it shall be imperative to determine admissibility of documents objected to. First is Exhibit TS2 tendered. Exhibit TS2 tendered is a one-page photocopy of a newspaper publication, the Daily Sun newspaper of 11th May 2015, tendered by the defendant. The claimant objected on the ground that it is not original but photocopy, and the certification by the CBN is wrong, as it is not the publisher nor the National Library. In his final written address, counsel further submitted that Exhibit TS2 tendered is photocopy of a newspaper publication and no explanation as to the whereabouts of the original. The witness who tendered it is the one who certified it, and he does not have the original. That only original or certified true copies from Daily Sun, National Library or Archives is admissible. That the newspaper is a worthless document as it will have no probative value. The defendant's counsel submitted that the publication of Daily Sun of 11th May 2015 is an attachment to Exhibit TS1, so the court ought to admit it, notwithstanding that it is not coming from the National Library. The court is entitled to look into its records and use the same publication attached to Exhibit TS1. Exhibit TS1 is the petition written by students of Tidek Polytechnic. It was not tendered with any attachment. The petition and the Daily Sun newspaper were independently pleaded in paragraph 7 of the statement of defense, which did not say that the Daily Sun newspaper was attached to the petition. The said petition, Exhibit TS1, did not even mention the said Daily Sun newspaper. So the newspaper could not have been an attachment to the said petition. I agree with the Claimant Council that the CBN is neither the publisher nor the National Library to certify a photocopy of the Daily Sun newspaper. The law on this point does not admit of so much argument or analysis as it is as good as settled that only original copies or certified true copies of a newspaper from the publisher or National Library, where it is a photocopy, is admissible in evidence. See the recent case of Williams versus Czech GlaxoSmithKline Consumer Nigeria PLC 2019 LPLR 47498CA. On this ground, the document marked as Exhibit TS2 is rejected and so marked. Shola. TS2 tender, mark it rejected. You people didn't want to bring the file. Go with it, go with it. You will see Exhibit TS2 tender. Mark it now with the word rejected. Exhibit TS3 tender. Exhibit TS3 tender is a special investigation panel report tendered by the defendant. The Claimant Council objected to this document on the ground that it was not front-loaded, as it is different from the one front-loaded in terms of number of pages. The document is a private document, but no explanation as to the original, and the certification cannot cure the defect. The document was filed as list of additional documents to be tendered, and no leave was sought to file additional documents, and there was no amendment to plead the document as a new document. In his final written address, Claimant Council further submitted that Exhibit TS3 is not admissible as it sought to replace a 27-page document that was withdrawn by Council during trial on 14th July 2021. Exhibit TS3 now has 31 pages and was correctly filed as list of additional documents on 17th August 2021, but without leave of court, and that renders it inadmissible for want of leave. He relied on Order 15, Rule 2 of the rules of this court. Fantasies versus Fantasies. Citation supply. Furthermore, that the document was not pleaded. The defense counsel responded that it is not a different document from the one earlier withdrawn. It was pleaded, and the CBN is a public institution, so the certified copy can be tendered. In his final written address, defendant counsel further submitted that CBN is a public institution and officer whose acts and records qualify to be public documents within the meaning of Section 102A III Evidence Act, cited Achimi versus Amodu Omale Audu. Citation supplied. The certification of that document by an officer of the CBN is proper. Now this court works. It is true that even though this document was not specifically pleaded, there are enough reference in the pleadings and witness depositions to the sitting of the Special Investigation Panel as to warrant the tendering of this document. See paragraphs 8 and 9 of the Statement of Defense. And paragraph 12 and 13 of the witness deposition of DW. It is also true that an incomplete version of this document was front-loaded and sought to be tendered but withdrawn on 14th July 2021, and the full document was filed as additional document on 17th August 2021, but without leave of court. In the circumstance, without denial of the existence of such a report, as Claimant admitted under cross-examination that he attended the sitting of the Special Disciplinary Panel, the interest of justice is best served by admitting the document. The objection to this document is overruled, and the document is admitted in evidence and marked as Exhibit TS3. Claimant counsel also submitted that Exhibit BOJ7 BOJ 8, BOJ 9, BOJ 14, TS1, TS1, TS3 are all photocopies and no foundation as to the whereabouts of the originals. These are documents, apart from TS2 and TS3, all the others are documents he did not object to their admissibility. But of course, you have a right during a final written address, having reviewed and seen that no, it ought not to be, isn't it? So according to him, DW is not the maker of the documents. They are private documents and only certified as private documents do not need certification. Only originals can be tendered, else the whereabouts of the original must be explained. That the CBN is not a public officer. Council relied on sections 1 to 3 of the CBN Act, CBN versus Njemenze, and NRMA and FC versus Johnson. The court has earlier held that the CBN is a public officer for the purpose of Public Officers Protection Act. CBN is also a public officer for purpose of Section 104 of the Evidence Act, and the documents belonging to the CBN are public documents within the meaning of Section 102 of the Evidence Act and not private documents, so they can be rightly certified by the CBN and tendered in evidence and admitted under Section 105 of the Evidence Act. The objection to these documents already admitted without objection fails.
The court places.
Whether the claimant was accorded fair hearing. We have moved to the main issue now, isn't it? According to the claimant, the defendant made out a spurious allegation of illegal operation of institution of higher learning against him. He did not receive any query from the defendant over any allegation of misconduct bordering on financial embarrassment. He was not allowed to see or cross-examine any of defendant's purported witnesses. He was not fairly heard before the illegal unlawful termination of his employment. According to the defendant did not subject the claimant to the Central Disciplinary Committee on the allegation of illegally operating an institution of higher learning, but for misconduct bordering on engaging in business that conflicted with the defendant's interest and financial embarrassment, relying on the query issued to the claimant on 9th May 2016. The claimant misconducted himself prior to his termination, which borders on financial embarrassment and engaging in business that conflicts with defendant's interest. These form the basis of the queries issued to the claimant. 2 witnesses testified in his presence and he cross-examined them. Learned counsel for the defendant also submitted that the 2 offenses that were considered as misconduct committed by the claimant are 1, financial embarrassment, and 2, engaging in business that conflicts with the bank's interest. The requirement of fair hearing were correctly stated by claimant's counsel, relying on the case of CBN versus Dine 2021 500 report, part 1798, page 130, where the Supreme Court held that in order to be fair, a hearing or an opportunity to be heard in a judicial inquiry must encompass a party's right, A, to be present all through the proceedings, to hear all the evidence against him or her, B, to cross-examine or otherwise confront or contradict all witnesses that testify against him, C, to have read before him all the documents tendered in at the hearing, D, to have disclosed to him the nature of all relevant material evidence, including documentary evidence prejudicial to him, except in recognized exception, E, to know the case he has to meet at the hearing and have adequate opportunity to prepare for his defense, F, give evidence by himself, call witnesses if he likes, and make oral submissions, either personally or through counsel of his choice. There are sufficient documents before the court to answer this question. These are Exhibit OBOJ 10, 11, 13, which is same as BOJ 7, then OBOJ 14 and TS3. Exhibit OBOJ 7, dated 18th February 2016, is an invitation on the claimant to appear as a witness before the Interdepartmental Investigation Panel. The heading of the invitation letter is, I put it in capital, Special Investigation Panel on an alleged case of illegal operation of institutions of higher learning against Mr. Johnson Babalola O, ID number 15331, Principal Manager, CBN, Akure. Exhibit OBOJ 11, dated 9th May 2016, which is the one the Defense Counsel was relying on, is titled Query. The opening and last paragraphs of the query are as follows. You will recall that you recently appeared before a special investigation panel on a case of illegal operation of institutions of higher learning. You are therefore required to explain in writing to the satisfaction of the Director, Human Resources Department, on or before Thursday, May 12, 2016, why disciplinary action should not be taken against you in accordance with Chapter 6.4.2.2 of the Human Resources Policy and Procedure Manual. Now, paragraph 6.4.2.2 of Human Resource Policy and Procedure Manual has 14 listed items as offenses that can lead to termination of employment, yet none was specified in the query. So is it all the listed 14 items, or how do we know? How do we marry it to only one of the items? I don't know. But then Exhibit OBOJ 13, dated 13th May 2016, is an invitation to the claimant to appear and defend himself before the Central Disciplinary Committee, CDC, on the above stated case. The case is stated in the heading as Central Disciplinary Committee on an alleged case of illegal operation of institutions of higher learning against Mr. Johnson Babalola O, ID number 15331, Principal Manager, CBN, Ado Ekiti. I don't know, maybe he was in Akure before they moved him to Ado Ekiti. I don't know, or was it their own error? In one, it is CBN Akure, but all others is CBN Ado Ekiti. Then Exhibit TS3 is titled Report of the Special Investigation Panel on an alleged case of illegal operation of institutions of higher learning against Mr. Johnson Babalola O, ID number 15331, Principal Manager, CBN, Ado Ekiti, February 22nd to 26, 2016. Similarly, Exhibit OBOJ4 is titled Central Disciplinary Committee Report on an alleged case of illegal operation of institutions of higher learning, TDEC Polytechnic, Ilogo Ekiti, against Mr. Johnson Babatola O, ID number 15331, Principal Manager, CBN, Ado Ekiti Branch. From the contents of the above document, it is clear that the claimant was queried and he faced both the Special Investigation Panel as a witness and the Central Disciplinary Committee as an accused person on the allegation of operation of higher institution of learning and not on allegations of misconduct bordering on engaging in a business that conflicted with the defendant's interest and financial embarrassment, according to DW and Defendants Counsel. The implication of all the above is that as far as any allegation of misconduct bordering on engaging in a business that conflicted with the defendant's interest and financial embarrassment are concerned, the claimant was not informed of such allegation. He was not queried for such allegation, and he did not face disciplinary committee on such allegation, so he was not given fair hearing, going by the case of CBN versus Dine Supra. The procedure before the Special Investigative Panel and the Central Disciplinary Committee. At the Special Investigative Panel hearing, Exhibit TS3, all the students of the Idigbe Polytechnic who allegedly wrote the petition, who appeared before the panel, did so individually in the absence of the claimant. Other witnesses were contacted and interviewed via phone calls, and the claimant appeared alone and answered questions. The procedure contravenes Regulation 6.4.2.2a, Exhibit OBOJ9, which provides that no disciplinary action shall be taken against an employee without an investigation to establish the facts, in the course of which the employee shall be given a fair hearing. It is their own rules. You must make investigation to establish the case, and even in the course of that investigation, the employee shall be given fair hearing. It is the finding of this court that they violated that rule. At the Central Disciplinary Committee, of the 5 witnesses who testified before the panel, 4 are staff of the bank, and only 1 is a former student of Idigbe Polytechnic. Of the 4 staff, each of them testified separately and thereafter in a joint session with the claimant, who was particularly given the opportunity to cross-examine 2 of the witnesses, but he said he had no questions. The 5th witness was one Vincent Friday, a former student of Idigbe Polytechnic. This witness testified in the absence of the claimant, and there was no joint session for him and the claimant, so he was not cross-examined. The evidence of this witness is on pages 31 to 35 of the report, that is Exhibit OBOJ14. He said he was not one of the students who wrote the petition against the claimant. The above procedure contravenes Regulation 6.5.4.2, which requires that the committee informs the erring employee of its sitting, the charges be read and explained to the employee, the plea of the employee be taken, the employee be given opportunity to defend himself, be given the facility to invite his or her witnesses, or to tender documents, and also to cross-examine opposing witnesses. The requirement of fair hearing is so sacred that is required. The requirement of fair hearing is so sacred that it is required, whether it is an investigative panel, disciplinary panel, or a commission of inquiry, so long as the right of a citizen will be determined or affected one way or the other by the outcome of the panel. It is the finding of the court that the claimant was not given fair hearing at the Central Disciplinary Committee. What is the stated reason in the termination letter, and whether the defendant can rely on a reason not stated in the termination letter as its defense. The termination letter of the claimant is Exhibit BOJ3 and dated 31st August 2016. The first paragraph contains the reason for the termination as follows. I am directed to inform you that your services are no longer required by the bank. In the circumstance, your appointment with the bank is hereby terminated with immediate effect. The claimant attended a special investigation panel at Central Disciplinary Hearing. See Exhibits BOJ 7, OBOJ 10, OBOJ 11, OBOJ 13, OBOJ 14, and TS3. But his employment was terminated on 31st August 2016 for services no longer required. CBOJ 3. The defense in paragraph 5 of the statement of defense is that the claimant was terminated for misconduct bordering on engaging in a business that conflicted with the defendant's interest and financial embarrassment. The place to look for the reason for termination of an employment is the letter of termination and not the statement of offense. In the present case, it must be observed that misconduct bordering on engaging in a business that conflicted with the defendant's interest and financial embarrassment, I put it in quote, cited as a reason for the termination of claimant's employment is nothing but what the defendant or its counsel thinks or suspects may have been or should have been behind the termination. In Iwoha versus Mobile Producing Nigeria Unlimited 2011 LPLR 4477 CA, the Court of Appeal held, in considering the issue whether the termination of the appointment of the appellant was right or wrong, the court must confine itself to the letter terminating the appointment and not go outside it to look for other reasons which the appellant thinks or suspects may have been behind the termination. That is what the court held. See also Elijah Taiwo Banu and 4 others versus Executive Governor Kwara State, suit number NICN IL 16-2019, unreported. A judgment of this court delivered on 18th day of March 2021. This court has severally held that where no reason or where a particular reason is stated for the termination of an employee and the defendant cannot turn around to advance a reason or a different reason for the termination, even if that reason existed in fact. See Jimo Gabriel Yemi versus Executive Governor Kwara State and 2 others, suit number NICN/IL/11-2019, unreported. The judgment of this court delivered on 29th of September 2020. Elijah Taiwo Banu and 4 others versus Executive Governor Kwara State and 2 others, suit number NICN/IL/16/2019, unreported. A judgment of this court delivered on 18th day of March 2021. Fidelis Fadubagbe and 4 others versus Governor of Kwara State and 5 others, suit number NICN/IL05-2020, unreported. A judgment of this court delivered on 3rd day of November 2021. See also Iwoha versus Mobile Producing Nigeria Unlimited 2021, LPR 4474 CA Supra. These cases I cited are the cases that I refer to when I said this court has severally held. And to the best of my knowledge, none of them has yet been set aside on appeal, although they are recent. When they are set aside, the learned AG will let me know. That is that is that particular holding that I said, if you did not state a reason or you state a particular reason, when the man sues, you cannot now begin to give reason or give a different reason. If you have appealed on that particular holding, which I don't think either, but if you have, thank you very much. So we are not even likely to have overruling on these decisions of this court for a long time until somebody decides to challenge it and say, no, if a reason indeed exists, even though you did not state it in the termination letter, you can still rely on it. And the Court of Appeal agrees with him, then it will overturn this one. Now, the allegation for which the claimant faced disciplinary panel was not the reason stated for his termination of employment in the letter terminating his employment. The defendant is stopped from relying on the allegation of illegal operation of institution of higher learning or misconduct bordering on engaging in a business that conflicted with the defendant's interest and financial embarrassment as a reason for the termination of at this point, as it is deemed to have condoned that fault, if any, was found against the claimant. See Nigerian Army versus Brigadier Maude Aminu Kano, 2010, 1 MJSC Part 1, 151, Lawrence Idemudia, Obokale versus Lasu, 2013, 30 NLR Part 85, 1 NIC, Chukudinma and Access Bank, 2015, 52 NLR Part 1, 76513 at 529. The implication is that the claimant's employment was neither terminated on grounds of allegation of illegal operation of institution of higher learning, for which he faced disciplinary committee, nor for misconduct bordering on engaging in a business that conflicted with the defendant's interest and financial embarrassment, an allegation for which he never attended any disciplinary panel in respect thereof, which allegations are deemed abandoned or condoned. The defendant cannot rely on an alleged offense which does not exist or which it condoned as justification for termination after the claimant has challenged his termination in court. See Ekunda versus University of Ibadan, citation supplied, Nigerian Army versus Brigadier General Maude, citation supplied, Lawrence Idemudia, citation supplied. The Supreme Court, in the case of Imolame versus Wayek, held that in an employment with statutory flavor, the parties are bound to obey the conditions contained in the statute, and anything done which is inconsistent with that shall be null and void and of no effect. And the claimant's employment be terminated for services not required. Whether or not the claimant employment gets statutory flavor should not take the court's time, as it is not in issue. The defendants even considered this under examination, even though the claimant, who is asserting that his employment enjoys statutory flavor, is also arguing that the defendant is not a public officer. The Supreme Court, in the case of Imolame and Wayek, defined employment with statutory flavor as where the contract of service is governed by the provisions of a statute, or where the conditions of service are contained in regulations derived from statutory provisions, they invest the employee with a legal statute higher than the ordinary one of master and servant. They accordingly enjoy statutory flavor. The rules of the defendant, Exhibit OBOJ 9, are made pursuant to Section 47 of the Central Bank of Nigeria Act, which provides as follows. Section 47, power of bank to make regulations. The board shall have power to make and alter rules and regulations for the good order and management of the bank. An employment with statutory protection cannot be terminated for services not required, but as provided for by the rules, and in strict compliance with such rules or else the termination is null and void. See Union Bank of Nigeria Limited versus Charles Ogbo. Citation supplied, where the court held inter alia, employment with statutory backing must be terminated in the way and manner prescribed by the relevant statute, and any other form of termination inconsistent therewith is null and void and of no effect. See also Eperokun and University of Lagos. Citation is there. Bamgoya and University of Ilorin. Citation is there. Chitabe and Federal Republic and Federal Public Service Commission, 1981, 1S report 1 at 56. The implication of all the above findings is that the claimant is entitled to reinstatement. See Mrs. Akinyo Soyeye, Missy and Federal Inland Revenue Services, 2012 LPLR 7964CA, where the court held the law is settled that the remedy for wrongful termination of employment with statutory flavor is reinstatement. See Olufeba versus Abdul Rahim, 2010, All Federation will report 512-1033. On the whole, the case of the claimant succeeds, and for the avoidance of doubt, it is hereby declared and ordered as follows. 1. A declaration that the termination of the employment of the claimant with the defendant by defendant's letter of 31st August 26 for services not required is unlawful, null, and void. 2. An order setting aside the termination of the employment of the claimant and reinstating the claimant into the employment of the defendant. 3. An order that the defendant pays the claimant all his salaries and allowances from the date of termination to the date of reinstatement and thereafter until retirement. This is the court and it is entered accordingly.
As the court pleases.
Yes.
My Lord, we are most grateful for the well-considered judgment. I have learned so much today, and we are grateful to your Lordship.
We are grateful.
We thank your Lordship, sir.
My Lord, we are also grateful for the well-considered judgment.
Oh, yes, son, we are grateful. Because we are going on holidays.
Yes, my Lord.
The copies of your judgments will be ready by tomorrow.
By tomorrow, we thank your Lordship, sir.
What I mean by tomorrow is if you come anytime tomorrow, you will pick a copy of your judgment.
As the court pleases.
As the court pleases.
Thank you.
As the court
pleases. We thank your Lordship, sir. We are most grateful.
You're welcome. Ruling. This one is short. This one is just 4 pages. Mr. Olasukanmi Paul Ogundayomi and Robber Estates Nigeria Limited.
Yes, my lord. Well, with great respect to the Honorable Court,
yes.
Chukuyem Atewe.
Yeah.
Chukuyem.
Okay.
Chukuyem, Y-E-M.
No, I am seeing it on the screen, on your screen.
As the court pleases, for the claimant. For the claimant.
Yes.
Respectfully, my lord.
We are grateful to the court.
Claimant responded.
Respectfully, my lord.
Yes.
EO
EO?
EO, initial, Osenidi.
Okay. Why is it that your video is off?
Oh, my lord, off, my lord.
Okay. The matter is for ruling. This is the ruling. In the National Industrial Code of Nigeria and the Akure Judicial Division holding at Akure before its Lordship Justice K.D. Damlak dated this 13th of December 2021, suit number NICN/AK/17/2021 between Olasun Kanmi Paul Ogundayomi, Claimant applicant. And Roba Estates Nigeria Limited, defendant respondent. Ruling. By a general form of complaint filed on 12 February 2021, the claimant claims against the defendant the following reliefs: a declaration that the termination of the claimant's employment with the defendant for no cause and reason, the claimant having meritoriously served the defendant for over 7 years without misconduct, is unjust, unlawful, unfair labor practice, and a violation of the defendant's employee handbook. B, a declaration that the termination of the claimant's employment with the defendant without recourse to the defendant's employee handbook is a breach of the contract of employment of the claimant, unlawful, unfair labor practice, and a violation of the defendant's employee handbook. C, a declaration that the defendant's query letter dated 4th day of November 2020 issued to the claimant is incompetent, invalid, and is a violation of defendant's employee handbook. D, an order of this honorable court setting aside the defendant's purported termination of the claimant's employment by its letter of termination issued to the claimant dated the 9th day of December 2020. The termination having been tainted with bias, malice, unfair labor practice, and is a violation of defendant's employee handbook. E, an order of this honorable court directing the defendant to reinstate the claimant to his post in the defendant without any loss as to seniority, salaries, position, and other emoluments. F, an order of this honorable court directing the defendant to compute and pay to the claimant all his salaries, allowance, and other emoluments due to him specifically from December 2020, when the employment of the claimant was terminated by the defendant up to the date of judgment, and or alternatively to prayer E and F above. A, an order of this honorable court for the payment of the sum of 5 million naira as damages and compensation for loss of job, psychological and emotional trauma arising from the action of the defendant in unjustly and illegally terminating the employment of the claimant in the defendant. B, an order for the payment of the sum of 2 million naira as cost of this action. Claimant also filed this motion on 12 February 2021 for an interlocutory injunction praying for the following. A, an order of interlocutory injunction restraining the defendant respondent, whether by his agents, servants, privies, and or persons commissioned to act for and on their behalf, from removing, evicting, and or taking any steps towards ejecting the claimant from the facility, residential apartment, and or house where he presently occupies, located at Management Quarter 10, Roba Estate Nigeria Limited, Araromi, Obu, Ondo State, pending the hearing and determination of this suit. An order that the parties in this suit hearing maintain the status quo ante, pending the hearing and determination of the suit filed by the claimant hearing, and for such orders as the Honorable Court may deem fit to make in the circumstances. The motion is supported by a 31-paragraph affidavit. The crux of the affidavit, which is mainly a reproduction of the statement of facts accompanying the complaint, is that the claimant has been an employee of the defendant since 11th March 2021. That cannot be. Sorry. I have to confirm because I know that has to be an error and not be 2021. Just let me confirm if it is his own error or mine.
Will be 2013, my lord. The claimant has been the employment
11th day of March 2013.
as my lord pleases.
6th day of March 2013, isn't it?
Yes, my lord.
Since 6th day of March 2013, the claimant was served a termination letter on 9 December 2020 for services no longer required. On 29 January 2021, the defendant served on the claimant a notice to quit the company's official residence being occupied by the claimant, that he does not have anywhere else to stay with his family. In the written address in support, learned counsel formulated a loan issue In the written address in support, learned counsel formulated a loan issue as whether there are facts and circumstances presented by the applicant to justify the exercise of his discretion by this honorable court to grant the order of injunction sought in this application. Learned counsel submitted that the claimant's occupation of the defendant's quarters is as a result of his employment with the defendant, so he has the legal right to remain on the premises, considering the fact that he is challenging his unjust termination, that there is a serious issue to be tried in his suit. The balance of convenience is in his favor and damages cannot adequately compensate him. The defendant filed a memorandum of appearance and statement of defense on 5th March 2021, and by a motion of the same date filed 12 paragraph counter affidavit to this motion. The crux of the counter affidavit is that the claimant was employed by defendants by letter dated 6 March 2013. The claimant, by reason of the employment, the defendant allowed to reside in the defendant house. On 9 December 2020, the defendant terminated the claimant employment and paid to the claimant 3 months' salary in lieu of notice as provided by the employee handbook. The defendant has terminated the employment of claimant, and claimant has no right to reside in the house. That the defendant has now employed another person in replacement of the claimant who is to reside in the house, and defendant new staff is deprived or refused the use of the house, that the defendant cannot be adequately compensated in damages. The damages will be adequate compensation for the claimant. The balance of convenience is on the side of the defendant. The claimant did not undertake to pay damages. In his written address, learned counsel for the defendant counsel submitted that the motion is incompetent for non-compliance with Order 41, Rule 8 of the rules of this court, that Order 22, Rule 5, under which this application is brought, talks about interlocutory injunction in causes of recovery of personal property subject to lien. The claimant is not claiming recovery of any specific personal property. The other submissions of counsel are in line with the depositions in the counter affidavit court's decision. The court has earlier set out the relief sought in the substantive suit and the relief sought in this motion. None of the counsel averted his mind to the nexus between the relief sought in the complaint and the relief sought in the motion for interlocutory injunction. It is therefore necessary at this juncture to take a very short course through decided authorities in the law relating to interlocutory injunctions for the sake of both counsel. We move to our course. In Nwanewu, you forgive my pronunciation or my inability to pronounce the name. Nwanewu and Nwanewu 2007 Nigeria will report part 1050, page 1 at 13. The Court of Appeal per Salawa JCA held. The scope of interlocutory injunction is limited to the actual rest in a suit. It is actually based on specific claims or reliefs sought in the substantive suit or appeal. In Kinpelu and Idigbe 2008 10 Nigeria Law Report per 1096 531 AC, the Supreme Court per Toby JSC held of blessed memory held. One factor for granting interlocutory injunction is the preservation of the rest. It is the province of the law that the rest should not be destroyed or annihilated before the judgment of court. In Stallion Nigeria Limited versus EFCC 2008 7 Nigeria Report per 1087 461 at 473 to 474, the court held. Where an interlocutory relief sought is not in respect of or directly related to a claim before the court is without competence and jurisdiction to hear it, since it is not in respect of a claim before it. Therefore, an application for interlocutory injunction will not be granted unless it relates to a subject matter which constitutes a triable issue in the substantive suit before the court. Finally, for this class, in Branston Properties Limited versus FBN PLC 2007 All Federation Will Report part 397 1954 at 1966, the court per Obumbi JCA held. An interlocutory application or motion should normally be based on the specific prayer in the substantive action before the court. And generally, if an interlocutory application or motion does not seek a prayer related to the cause of action, the application or motion is incompetent. In the instant case where there are no claims for an injunction in the substantive relief sought, the application for interlocutory injunction is incompetent. Quotation clause. From the above decided authorities, it is clear that this court has no jurisdiction to make any pronouncement on the official residence, the subject matter of this application, as it is not the subject matter or a subject matter in the complaint, and no relief is sought in respect of the said house in the complaint. This application is incompetent and same is hereby struck out, each party to bear its cost. This is the ruling of the court and it is entered accordingly.
As the court pleases.
My Lord, we are very grateful for the well-considered ruling. We are grateful, my Lord.
Is that active?
Yes, my Lord. We will thank my Lord for the well-considered ruling. We are grateful to the court. In the circumstance, my Lord, we shall be asking for date for trial in the suit, in the main suit.
date? Do we not have a date?
My lord, we don't have a date.
For this ruling, sir.
We only had a date for this ruling.
Yes, my lord.
Okay. 17th February for hearing, physical hearing.
It's convenient, sir.
It is convenient, my lord.
You are welcome, gentlemen.
It's convenient, sir.
Very grateful, my lord.
Please. All right, thank you, gentlemen. That is all for the Zoom matters today.
As the court please it.
We will all leave.
Thank you, my lord.